I think part of also what underlies the disputes here is, I think on the defense side there is this assumption, and I've seen the little nifty slides, kind of like Joe Rice's apple tree, fruit tree slide, some of you may have seen at a recent conference, that the trusts, universally, without exception, operate as ATM machines where we provide our name, social security number of our client, so forth, and a magic set of dollar bills pops open, and we can file that anytime, get the money anytime. And what we're not wanting to tell you is the secret code we give them. Oh, I'm Joe Rice, I get this much, and I'm the Simmons firm, and I get that much. And therefore, we have the ability to get this money, ask for it, and get it whenever we want it. And that these claim forms are going to do some sort of magic bullet that will enable you to avoid liability and for your other defendants. And the fact is, I think it goes back to Elihu's true model of the empty chair. I mean, the trust is simply a defendant who was there and no longer is. And just like when the defendant was there, in some cases the law firm on behalf of the plaintiff knows what it is. They worked at Granite City Steel in my neck of the woods. Everybody knows what's there. Everybody knows what's there. Or if they work somewhere less known, I mean, we represent clients nationwide. We may get someone working at a foundry and somewhere in Utah on some secret government project, and it takes us a long time to figure out what was there, track down people. And some of these these case management orders and others that basically rip things out of context and say, oh, bankruptcy trust claims are different. They're different in how you make them, they're different in how they pay, and therefore you should know the minute the client signs with the law firm what every exposure is to every trust. It's just ridiculous. And I do think it is from that model that perhaps, I'll give you credit, based on some things that have happened in litigation in general, I'm not going to necessarily criticize some defense lawyers for having their suspicions about the way these things operate. But it's not the case that these things are ATM machines with no levels of proof, and it takes a while. The example was the plaintiff comes and signs with the law firm, and they know their work history, but they don't know the products. Well, a lot of times anymore, it's not the client. They're already dead. It's 18, 23 months since they died, and we're signing with the daughter, the child, who really doesn't know other than daddy worked at a steel mill somewhere in Kansas. And we have to order Social Security records, we have to do things. It takes months and months and months just to put together basic information to be able to find out, the rudimentaries of the case. And so when you put these things together with all these special asterisks and footnotes treating bankruptcy claims different than other defendants, I don't think it's fair and I don't think it's accurate. But I don't disagree in theory, Jim, with the idea, and maybe I'm even disagreeing with Elihu a little bit here, the proof of claim form and the amount, that is settlement discussions. Those should be governed the way any other settlements are given. But the claim form is just where he worked, the product, it's the medical. It's not like we have one set of medical and another set of medical. The medical is the medical. And we have to, the standard of proof for most of the trusts, frankly, is higher than what I see defendants pay in the tort system every day. And the exposure is the exposure evidence. And a lot of times it's coming from the interrogatory responses, the depositions, and everything else that's already out there. Sometimes it's not. I know everyone's got theories about our claim forms and affidavits and so forth. But I think at the end of the day, that information should come in. If you're going to go to verdict on somebody and you've gotten a payment on the side, I fundamentally disagree. You should be able to keep that secret. No way. And if you haven't made the claim yet, and you could have made the claim, of course the defendant should be able to stand into your shoes and make that claim and should be able to get some cooperation. But just to single these things out and to put these CMOs together that treat them as some special ATM machine that's somehow different, I think is what's really what's at the heart of what's wrong with all this.
You've raised the issue, which is the concern that cases are being pursued, finished, and then our trust claims being filed at that point. I understand in some cases you may not know everything at the timing of the filing of the complaint. I think in West Virginia there's a sort of a requirement that you supplement. But I think the defendant's concern, I think why you're seeing these come up particularly with regard to bankruptcy trusts, is the concern that claim gets filed, when it's resolved, it is at that point that trust claims are getting filed. And the information that you would have had potentially in the tort case, you never have access to.
I come to learn, I think a lot of people, maybe even in this room, aren't aware of, though I would think they would be, is the historical oddity of the fact that these trusts, the majority of them, the ones with the big money we're talking about when we throw these numbers around, were created in 06, early 07, opened in 2007. all of them had these grace period windows, tolling statute of limitations, because Section 108 of the Bankruptcy Code provides that your claim running a statute of limitations is tolled during the bankruptcy. And to avoid this crush of hundreds of thousands of claims in the 30 days, which is the time you get to reactivate your claim under 108, have them crush the trust, they said, well, look, if you had a claim when we filed, if you got a claim while we were in bankruptcy, we're going to give you 3 years to get it in here. And from that point forward, when the 3-year window closes, you're going to be governed by the applicable state statute of limitations that operates to govern your claim. I think a lot of what has happened, I mean, there are issues to work out going forward, obviously, but a lot of the complaints from defendants, especially I think local defense counsel, who are seeing like, wait a minute, we're going to trial. Let's say this is an anecdote from 2008 or 2009. We're going to trial, and we settled at the courthouse steps, and now those SOBs are making bank claims to those same clients. Well, they could, because there was still a window there. For most of trust, there isn't one. I mean, there's, in the next year, pretty much all the 2006 trust windows will expire, and everyone will be under SOL, and there isn't going to be the ability to sit there and take 18 months or whatever to go to trial and then turn around and file these claims. It just isn't going to be there, and so these things are necessarily going to get filed and dealt with during the pendency of the state court action.